Hello, everybody. We all are aware of the fact that transfer pricing has become a significant focus for revenue authorities worldwide, including South Africa as well. The OECD has spearheaded the global effort to combat profit shifting through its base erosion and profit shifting project, which is uh, commonly known as the BEPS project. To address transfer pricing directly, South Africa has also enacted Section 31 of the Income Tax Act. The South African Revenue Service, which is SARS, has also published its Interpretation Note 127 on thin capitalization and the application of transfer pricing rules to intercompany loans. However, transfer pricing cases were yet to surface in the public eye up until now. The tax court's ruling in ABD Limited, which is the Tax Court of Johannesburg, not only marks a pivotal moment for South Africa's tax profession, but also provides a valuable roadmap for understanding transfer pricing fundamentals under South African tax law. And this is the first judgment dealing with transfer pricing in South Africa. This will serve as a useful guide to the basics of transfer pricing within the context of South African tax law. So let us discuss the background of this particular case. So the taxpayer ABD Limited was a telecommunications company situated in South Africa, and it had various subsidiaries operating in different countries. Between 2009 and 2012, the taxpayer licensed its intellectual property to these opcos against the payment of royalty. A flat rate of 1% was charged as a royalty from all the opcos. So every opco was charged a rate of 1% of royalty. The taxpayer had chosen this royalty rate on the advice of an independent external consultant, which had researched the most appropriate arm's length rate at which to charge the royalty and presented this research to the taxpayer. SARS, however, took the view that this 1% royalty was, in fact, not at an arm's length and should have been higher. Therefore, relying on Section 31 of their Income Tax Act, SARS raised additional assessments for the taxpayers' 2009 to 2012 tax years. Initially, in coming to this conclusion, SARS had relied on an expert report that it had commissioned. However, during the course of the proceedings before the tax court, SARS used the services of another expert who recommended that SARS adjust the royalty rate even further. This second expert's opinion was based on his view that the taxpayer should have charged a variable royalty rate based on both the relevant economic factors for the year in which the royalty was charged and the country in which a specific opco was situated. SARS change in expert led the taxpayer to argue that SARS was flip-flopping and also challenged the additional assessments on procedural grounds. The tax court, however, did not come to a decision on the procedural arguments, but decided to consider the case on its merits. So the main issues before the Tax Court of Johannesburg were what will be the impact of arm's length principle on the royalty transaction, whether which method has to be used if CUP, which is comparable uncontrolled price method, is used, and what is the suitable comparable transactions that can be used. Now, coming to the judgment of the court, given the lack of precedents, both the taxpayer as well as SARS placed great reliance on the transfer pricing guidelines, which have been published by the OECD. The court referred to the definition of arm's length pricing from these guidelines and also the approach to testing what an arm's length price would be in a specific situation. Two of these approaches were used by the taxpayer to justify its choice of royalty rate. One was the transactional profit split method and the comparable uncontrolled price method. SARS had relied on the transactional profit split method. In particular, the tax court decided to consider the comparable uncontrolled price analysis as it found that there was a similar transaction involving the same intellectual property, which the taxpayer had concluded previously with an unrelated company. SARS, however, challenged the reliance on this method on the basis that the previous transaction was not comparable and so it was not applicable or could not be used in this particular case as a comparable. Now, a few observations of the court, of the tax court were, firstly, the tax court pointed out that there was no motivation or rationale for the taxpayer to charge the opcos an artificially low rate of royalty. This is because the countries in which the opcos operate had tax rates equal to or in excess of South Africa's tax rate, and it was therefore not necessarily more beneficial for the taxpayer to charge lower royalty rates, since the effective tax rate across jurisdictions of the group as a whole will remain same or similar at the same levels essentially. Further, there were also minority shareholders of the opcos that would benefit from more of the profit generated by those opcos being retained in the opcos, which would not likely be the taxpayer's intention. Although SARS did contend that this was an irrelevant consideration, and the tax court also agreed to some extent, arguably there was nevertheless some weight attached to it for the reason that this pointed towards the taxpayer's genuine reliance on the report presented to it by the independent external consultancy. Also, the tax court found that there were sound commercial reasons for the taxpayer adopting a flat royalty rate across all the opcos. Finally, the tax court ruled that the 1% rate of royalty charged from the opcos was at an arm's length. So the ruling was in favor of the taxpayer. No adjustment was made. Now, this decision is important for multinationals having international transactions and operating in South Africa, since this will give a lot of guidance. It sets a precedence on the transfer pricing principles. It also highlights the importance of the global standards as well as OECD TP guidelines to be used while undertaking an arm's length analysis. That's it for today. If you like these videos, do like and subscribe for more similar content. Thank you.